coming up on Lawmakers. Legislation that aims to crack down on illegal immigrants and those who employ them gets another step closer to the governor's desk. Conferees agree on tough new sexual predator legislation. And a bill that aims to protect the unborn from violent acts passes the House. Those stories and more are coming up next.
This is Lawmakers, your source for all the news from under the Gold Dome. Here are your anchors, Gerald Bryant and Nwandi Lawson.
Good evening, everyone. And Nwandi Lawson is off. David Zelski will be joining me just in a moment. Also on Lawmakers tonight, final passage of the bill that would create elective classes in Georgia's public schools about the Bible as history and literature. And the House votes to strengthen child abuse reporting requirements. But first, our lead story tonight. An agreement is reached on immigration legislation. The Senate has agreed to the Conference Committee report on Senator Chip Rogers' immigration reform legislation. Senate Bill 529 addresses areas such as hiring undocumented workers, as well as human trafficking and access to public services. Lawmakers Jesse Freeman is standing by live at the Capitol with more on that story. Jesse.
Well, Gerald, the Conference Committee report on SB 529 removed a House amendment that would charge undocumented residents a 5% fee on money transfers. Opponents said that was unconstitutional, and even Senator Rogers admits he had concerns about the measure. The Senate voted today to agree to the Conference Committee report on Senate Bill 529. The version does not include language that the House added that would create a charge on international wire transfers. We
removed the 5% wire money transfer fee. We set a beginning date of any portion of this bill on July 1st of 2007. We removed some of the asset forfeiture provisions in the human trafficking area of the bill.
The motion to agree sparked floor debate from the chief adversaries on the issue, Senators Chip Rogers and Sam Zamarripa.
It is a hardening of certain criminal penalties. It sets up certain exclusions for the federal law. It makes certain provisions related to law enforcement. But this is not immigration reform.
Since this bill left the House, there were a few issues that came up that we dealt with and changed.
One part of the bill would require employers to check potential employees' residence status. That part of the bill will be overseen by the Labor Department.
As the Labor Commissioner, I want to make clear that whatever law is passed, we will do everything we can to implement it and carry it out. But I would hope they would provide us with the legislation that will allow us to do a good job in addressing this very complicated issue.
The Senate agreed to the report by a vote of 39 to 16. And Senate Bill 529 now requires House approval and Governor Sonny Perdue's signature to become law. Reporting live, I'm Jesse Freeman for Lawmakers.
Legislation that would impose harsher penalties on convicted sexual offenders only awaits the governor's signature before it goes into effect. Lawmakers Katie Eubanks is live from the House chamber with more on House Bill 1059. Katie.
David, this sexual predator legislation began in the House with bill author Majority Leader Gerald Greene. The legislation passed the House by a vote of 144 to 27 and moved on to the Senate, where it was assigned to the Judiciary Committee. In the Senate Judiciary Committee, over 40 proposed amendments were evaluated, with many being adopted. These included expansions to the Romeo and Juliet exceptions and a provision that would require sexual offenders to have marked driver's licenses. The bill then moved to the floor of the Senate, where it was passed by committee substitute by a vote of 53 to 1. A conference committee was then appointed to work out the differences between the House and Senate versions of the bill, and Majority Leader Greene reported on these negotiations today.
We do have an agreement, and I'm extremely pleased about the bill. I think what we said the day we started this process was our goal was to complete and send to the governor for his signature the toughest child sexual predator law in the country, and we have done that. We, on the Romeo and Juliet provision, which took a lot of discussion, we actually expanded that to 4 years. We did also change on the areas where you live and work within 1,000 feet. But if you're a sexual offender, not a predator, okay, you would be allowed to work at a place other than a church, a school, or a daycare center. So it expands a little bit. If you're not a predator, you're only an offender. The driver's license provision came out very early in conference. It's not in there. All the language regarding to that came out.
The bill now only needs the governor's signature to become law. If signed, it will take effect July 1st. Reporting live from the House chamber, I'm Katie Eubanks for Lawmakers.
In other news, the bill allowing the Bible to be taught in public schools as literature and history got final approval from the General Assembly today. The bill's author, Senate Majority Leader Tommy Williams, asked the Senate to agree with what he considered minor changes made by the House.
Thank you, Mr. President. Senators, this is the bill that allows the Bible to be taught as history and literature in the public schools, not for indoctrination. It requires that the Bible be the text. The bill is virtually the same as it passed out of the Senate, other than a paragraph of illustrative language that was in the bill, but the meat of the bill is exactly the same as it passed out.
The Senate voted 45-2 to agree with the House changes to Senate Bill 79. That was final passage. So the bill creating an elective course with the Bible as a textbook now goes to Governor Perdue for his signature. Senate Democrats issued a statement today saying they proposed the legislation first and praised what they call improvements the House made to the bill.
The House passed a bill that changes provisions when it comes to crimes against women who are pregnant. Among other things, Senate Bill 77 changes the time during a pregnancy when the murder of a pregnant woman becomes a double homicide. Now, even though Representative Tom Bordeaux had problems with some of the language, he, along with the rest of the House, voted in favor of Senate Bill 77. Representative Sue Burmeister explains how this bill changes the current law.
Make it a crime to harm a pregnant woman and her unborn child anywhere in Georgia. Someone who commits vehicular homicide and kills a pregnant woman would be charged with 2 deaths. A perpetrator who commits domestic abuse against a pregnant woman could be charged with assault against the woman and her unborn child. If a pregnant woman is murdered, the suspect could be charged with double homicide. Currently, our feticide laws allow such prosecution, but only after 20 weeks of gestation.
If a woman came to me and said, Mr. Bordeaux, I got rear-ended by a drunk driver, and I think I was about 2 weeks pregnant, I, as a lawyer, would say, your claim is for the loss of that child. And for the life of me, I can't figure out what the difference would be between that type of, I think, logical, common sense, personal injury, civil claim, and if that drunk driver, on the other hand, had intentionally run into her and caused the death of that baby.
Again, Senate Bill 77 passed the House unanimously and now goes back to the Senate for their approval of the House substitute. Reporting live, I'm David Zelski for Lawmakers.
Meanwhile, the bill allowing pharmacists the option of refusing to prescribe abortion-inducing drugs may have some new life. Senate Bill 123 never made it out of committee in the House. Today, Senator Jim Whitehead amended another bill to include the abortion drug language. The underlying bill, House Bill 1178, would allow the medically indigent access to some unused drugs. Senator Regina Thomas had some concerns about that bill.
You said earlier that, is it not true, nursing home residents, when they're no longer using them, when it's their time, that these drugs can be sent back, if not true, to the pharmacy?
Correct.
So they would not just keep them at that facility and use them for other residents at that particular nursing home?
Senator, there will be a program set up and designated pharmacies that will receive these drugs, and the only drugs that will be sent back are the one in the little blister packs, single dosage packs, and there will be log books, so there will be control of when it leaves the nursing home, the amount, as to when it comes to the pharmacy. So there will be control mechanisms to be able to account for each of the medicines.
House Bill 1178 passed by substitute with the Whitehead amendment. The vote was 32-15, and the measure goes back to the House.
The House today approved a measure to shorten the reporting period allowed in cases of child abuse. Representative Sue Burmeister presented Senate Bill 450.
This bill, if it becomes law, will take a big step forward in protecting the lives of abused children. Our child abuse law in Georgia is currently weak in 3 areas, and this bill proposes changes to address these deficiencies. The primary revision deals with the urgency in reporting suspected child abuse. Today, if a teacher or nurse believes that a child has been abused, they must report their suspicion as soon as possible. That's right, as soon as possible. That may be interpreted by some as a few hours, or others may think it means a few days or even weeks. Line 23 on page 1 simply removes as soon as possible and replaces it with language requiring that an oral report must be made within 24 hours after there is suspicion of child abuse. This report can be made by simply calling 911 if for any reason it cannot be made through normal reporting channels. This change eliminates the vagueness that exists today when it's necessary to report suspected child abuse.
Now, the House approved without opposition. It now goes to the governor for his signature.
A group of citizens organized as the Family Reclamation Movement rallied today at the Capitol in hopes of convincing lawmakers to make state agencies accountable for fraud in child removal cases. Lawmakers Lauren Brown has that story.
Families in support of the Family Reclamation Movement not only met on the Capitol steps, but drew up a petition urging legislators to fix flaws in the state's social services and foster care system.
Once a child, such as my son and a lot of parents that are here today, once a child has been proven to never been injured, never been neglected by their parents, they should be immediately returned. Don't keep our children in a system for money, because it is a huge money issue. And the thing is that we are asking our legislators to pass a bill so that someone is held accountable once that information has come forward that the parents are innocent.
While both the Department of Human Resources and the Department of Child and Family Services were unavailable for comment, Senator Renee Unterman, Vice Chair of the Health and Human Services Committee, spoke to lawmakers. And in her opinion, this issue isn't as large as some are making it.
I don't think government is interfering in families being able to take care of their children. But if they do have legitimate complaints and they do complain legitimately to the correct people, I'm sure they're going to listen and we're going to look into it. I have no problems with looking into it. But specifically in my particular district and within the budget that I'm over, which is DFACS, I've had absolutely no complaints.
According to the Family Reclamation Movement, nearly half of all child abuse allegations are noted to be unfounded. In addition, they feel these laws discriminate against low-income and single-parent homes. For lawmakers, I'm Lauren Brown.
A measure granting grandparents additional legal powers and potential money when they are the guardians of their grandchildren stalled in the House today. Representative Sue Burmeister said Senate Bill 420 would greatly assist the 100,000 Georgia families headed by grandparents or great-grandparents. But debate arose around the cost of the program.
We're saying to grandparents that if they are taking care of their grandchildren due to terminal illness or hardships created by death, serious illness, terminal illness, or incarceration of a parent, or a natural disaster or active military duty, they are important. Those children are important to those grandparents, and they want to care for them. And we're saying as a state that we agree. Article 4, Part 1 on page 2 talks about the power of attorney for the care of a minor child. Talks about all the different areas that they can do. School, they can enroll a child in school. They can take care of the health of their grandchildren and other provisions they need to provide, such as food, lodging, housing, recreation, and travel.
Page 8, lines 19 through 27. I won't read them, but I'll tell you there's a cost associated with doing this. The question is the cost greater than the cost of putting the child in foster care or not? I don't know that. But to me, as a responsible legislator, I would look for a fiscal note. I would like to know in writing what will the cost be.
Now, House Rules Chairman Earl Earhart ended debate on the bill with a successful motion to recommit Senate Bill 420 to the Rules Committee.
The bill giving additional prescriptive power to optometrists is headed to a conference committee. Senator Seth Harp spoke for House Bill 1390. Senator Don Thomas wanted to amend the bill. First, Senator Harp.
What this bill does is it allows for the use of limited oral medications, a formulary which is compounded and directed by the Board of Optometry to to treat only infections of the eye and eyelid. No more than that.
House Bill 1390 as written is overly broad. It allows optometrists to really prescribe any one of the drugs in the 3,538 pages of the PDR, and believe you me, we think they might not do that, but let me assure you that some of them may. This amendment that I have introduced, Amendment number 1, gives optometrists what they say they need. It gives them the 4 antibiotics that they originally asked for, and which was in the Senator from the 29th bill.
The Thomas Amendment limiting optometrists to prescribing 4 oral antibiotics passed. Another amendment requiring another level of oversight by the Composite Board of State Examiners lost. House Bill 1390 passed by substitute with the one amendment and went back to the House. The House disagreed with the changes, and a conference committee was appointed to come up with a compromise measure. Meanwhile, the House passed a resolution today that sets up a joint comprehensive state trauma services study committee. Lawmakers David Zelski researched Georgia's trauma network back in 2003 and recently had a chance to talk with Senator Cecil Staton about Senate Resolution 785 and why he believes the current trauma situation must change.
The Grady Health System ER is one of the 5 busiest trauma centers in the nation.
Trauma systems are all about getting the right patient to the right hospital at the right time, the golden hour. There also needs to be recognition of the fact that many trauma patients are uninsured. They're working farmers. They're blue-collar guys. 80% of the uninsured in America have jobs or are members of working families, but they work in jobs that don't provide health insurance.
People who are shot, stabbed, or in a major car accident are always taken to a Level 1 trauma center. But what happens if they live nowhere near a Level 1 center?
I would argue with any rural legislator in the state, just look at the map. We have atlases that show trauma death rates by county, and they are packed with rural counties in Georgia. That is driving this problem. Their constituents are the ones who are paying the price in lives, in disability, in premature death, in costs. Their little hospitals are paying the price with those tragic and preventable deaths.
Today's passage of SR 785 sets up a study committee who over the next year will take a closer look at improving Georgia's trauma network. Senator Cecil Staton explains why a new system is necessary.
We need a first-class trauma care system in our state so that no matter where you live, if you or a member of your family need trauma care, you'll have a facility relatively close by where you can go and get the care that you need.
The Medical Center of Central Georgia is currently in danger of losing its Level 1 status. And Senator Staton says if that happens, 3 trauma centers to cover Georgia's 9 million people will not be enough, and the number of preventable deaths could increase.
I heard a horror story recently of a family doing just that, driving down I-75 south of Macon. One of the members of the family in the car ended up in Gainesville, Florida. Another passenger in the car ended up in Tampa, Florida. Now, what's a family to do in a circumstance like that? We've got to make sure we have adequate trauma care in this state, and I'm committed to doing something about it.
It would save money for the state. It would save a huge number of lives. It would prevent a lot of disabilities, and it would ultimately serve the economic enterprise in this state by making Georgia a more attractive place for families and businesses.
An undertaking like this can be expensive, but Senator Staton believes this is something that has to be done. Reporting for Lawmakers, I'm David Zelski.
If Governor Perdue signs House Bill 1320, Georgia will have some new highway littering regulations. The House today agreed to Senate changes to the legislation. Here's Senator Ross Tolleson.
What this does is creates a new category of person who can dispense medicine within a particular, what we call a community living arrangement. These are not-for-profits. These are sanctioned by the Department of Human Resources, and they're primarily for our developmentally disabled.
That was actually Representative Jeff Brown. That was not Ross Tolleson. That is not the correct story there, but Senator John Bullock actually proposed 2 amendments to the Senate substitute to the litter bill. One would require that authorities have to prove someone's intent to litter. The second amendment would exempt fresh farm produce from being defined as litter and make the penalty for littering less harsh.
In other news, the Senate today passed the Georgia Street Gang Terrorism and Prevention Act. House Bill 1302 updates the state's current gang law. Senator David Edelman spoke for the measure.
It creates this new aggravated offense so that if you commit a crime while being a member of a gang, the prosecutor can prosecute those two separate crimes rather than choosing between the two. Second, it creates a new crime of tagging, which I'm no expert on tagging, but it has to do with graffiti associated with gang activity. Third, it is an effort to try to get some control over gang recruitment practices. Typically, I understand from the presentation at the committee, gang members are recruited in the schools. It puts certain restrictions, actually adds to the current restrictions as to who can be on school grounds, and makes it a misdemeanor if someone who's unauthorized is on school grounds, is requested to leave the school grounds by the principal, but refuses.
You don't have any concerns that anything in the bill might involve anything approaching or, in fact, approach anything like profiling. Is that correct?
I don't. As I heard the testimony before the Judiciary Committee, that was something I thought about, and I don't think this runs any greater risk of profiling than the risk that may already exist in the law.
And House Bill 1302, that's the Georgia Street Gang Terrorism and Prevention Act, did pass the Senate. It passed by substitute, however, and that means that it goes to the House.
Also passed in the Senate today, the Taser Certification Act. Senate President Pro Tem Eric Johnson explains the substitute to House Bill 1019.
Would set up legal requirements for the use of this weapon, procedures by every department, and updated training every year. I'd urge your adoption.
What is the penalty if an officer violates these rules? Currently, if they use these, it's up to the discretion of the department or what? Just what's the penalty if the rules here are violated?
It does say that if you violate the policy, you're subject to disciplinary action. I do not believe that disciplinary action is identified, but it's under Chapter 8 of Title 35. So there is a specific code section that deals with law enforcement disciplinary action, it seems to me.
House Bill 1019, the Taser Certification Act, passed by substitute. The vote was 52-1 because the Senate changes, the bill returns to the House. The House also today voted to change the scope of practice for certified nurse practitioners. However, debate of Senate Bill 480 included an attempt to amend the bill to outlaw clinics operated in pharmacies. Representative Jeff Brown presented Senate Bill 480.
What this does is creates a new category of person who can dispense medicine within a particular, what we call a community living arrangement. These are not-for-profits. These are sanctioned by the Department of Human Resources, and they're primarily for our developmentally disabled population. And without this, we really are going to have a problem. And basically what they are doing is giving the same medicines that if they were able to on their own, they could take on their self-basis. So it's a very straightforward bill. If you look at the bill, it enumerates what types of medicines they may give, talks about their qualifications, it talks about their certification, and any disciplinary actions.
Georgia has a severe nursing shortage. We have a severe shortage in our hospitals all over this state. And when the mini clinics, there's only 8 of them now, but Target has announced that they're looking at it. Walmart is doing it in other states, and Kroger's is considering it.
Attempts to amend the bill were unsuccessful. The House approved Senate Bill 48 by a vote of 163-5. The House also today gave members who will not be returning to that chamber next year a chance to bid their colleagues farewell, beginning with Representative Ron Dotson, who compared himself to Ray Stevens and Larry the Cable Guy.
My first great debate as a freshman here in the House was probably the dumbest thing I've ever done. I picked my first debate to be on sovereign immunity. And perhaps the lawyer that was then the chairman of the Judiciary, has the highest IQ of any member of this House, was the guy that I picked to debate with, Tom Bordeaux. Sovereign immunity, Tom, way back. Here was a guy with an IQ that I have no idea what it is, and here was a lawyer, and here's a contractor with an IQ so high that just 2 weeks before he had shot his hand to the floor with a nail gun.
I've been blessed in my life in many ways. I have a good wife, a great wife. I have healthy children. And about midway through this session, I kind of figured out why the Lord sent me down here. And I think it was to humble me. He wanted to get me down here and just kind of humble me. I've been a businessman all my life, been kind of doing things like I want to do them and, you know, getting them done now and without much discussion on that. So I think he kind of figured sent me down here to get me humbled a little bit.
I thank you for being there to support me when I needed you the most. That will be ultimately what I remember most about our friendship here in this House. Mr. Speaker, thank you. Thank you, Mr. Speaker, for all you have done for this House as well. And Representative Murphy, I yield the well.
Representative Dodson has decided not to run for re-election. Representatives Murphy and Reese will run for State Senate.
Pending approval by the governor, Colquitt will be declared Georgia's first mural city. The House today gave final passage to Senate Bill 484. Representative Gerald Greene presented the bill.
This bill was the inspiration of the Colquitt Miller Arts Council and the people of Middle County. And you can see behind me 2 of the murals that have been painted in the city. They have 10 of these, and they're completing the 10th one and ready to start on number 11. These murals cost between $25,000 and $50,000 a piece. The city of Colquitt in Miller County is also famous for Swamp Gravy, our state folk festival, the Mayhaw Festival, and a new sound and film stage is being constructed in the city at this particular time. And I would ask you today to recognize Colquitt as the first mural city of Georgia. And with your vote for Senate Bill 484, the vote would be for economic development, tourism, and the respect for community values that will carry forward to the next generation. On behalf of Colquitt and the Miller County people, we're asking you to support this on their 150th anniversary.
Senate Bill 484 passed 152 to 1. It goes to Governor Perdue.
Coming up tomorrow on Lawmakers, it's Legislative Day 39, and the countdown to sine die begins. Many major legislative issues, including the state's $18 billion budget, have yet to be decided. We'll have all the latest from under the Gold Dome tomorrow night at 7 p.m. If you have missed any part of this Lawmakers broadcast, tune in tomorrow morning when Lawmakers repeats at 5:30 a.m. Now stay tuned for Antiques Roadshow, FYI. That's coming up next here on GPB.
Actually, if you've missed any of the broadcast, you're fortunate. That's our broadcast for this, the 38th Legislative Day of the Georgia General Assembly. I'm Gerald Bryant, and I'm relieved.
And I'm David Zelski, filling in for Wandy Lawson. Thanks for joining us, and have a great evening.
Good night, everybody.
This has been a production of Georgia Public Broadcasting.